This podcast is not a source of legal advice. No two legal cases are the same. Contact an attorney if you require legal assistance.
So you have it.
Facts.
Today on the Mighty Merp podcast, I'm thrilled to welcome back someone who has become a true friend of the show. Powerhouse trial attorney, Richie Lomurro.
Let's go.
Richie isn't just a litigator. He embodies what it means to be a trial attorney in a profession where many attorneys write, negotiate, and advise from behind the scenes. Richie is one of the rare few who lives in the courtroom and thrives under the pressure of trial. In this episode, we're diving deep into the craft of being a trial lawyer. What sets litigators apart from the other attorneys? How to prepare for trial with discipline and clarity? Why mastering the rules of evidence can break or make a case? Richie brings an authenticity and passion that makes these conversations not only educational, but energizing. Whether you're a seasoned attorney, a young lawyer finding your voice, or simply someone who loves the strategy and storytelling behind the courtroom work, this episode will give you a candid look at what it truly takes to step into the arena with confidence. Welcome.
I have the man in the arena quote right up there.
That's funny.
Yeah, fitting, very fitting.
Yeah, it's one of my favorite quotes. I like the Brene Brown quote that also follows the man in the arena quote, which says something to the effect of, and for those who are not in the arena, your opinion does not matter.
Oh, I mean, one could argue I need to go get that one next.
Yes,
Yeah.
and she says it a little bit more succinctly and maybe a curse word or two in there, but yeah, definitely embrace that. So welcome back.
Good to be back.
You are joining a very rare group of guests that I think it's your third time, correct?
It's my third time. Is there any other third timers? Are there any third timers?
There was one other that happened last week.
Is it
but
gettable?
I let that. What?
Is it guessable?
Yeah, I'm sure it's guessable.
Oh, all right.
But I let that person know. I think she's the first three-timer, but that it would be a very short-lived.
Yeah.
I said you have it for only about a week.
Yeah.
So.
Well, she can enjoy a week, and then I'm kicking the butt right there. I'm in.
You're right there.
I'm
right
in.
there. All right. So if our listeners don't know your origin story, I would say go back to the first time Richie was on the podcast, and you can hear his origin story. But not really about why or how you became an attorney, but more about, did you always know that you wanted to be a litigator and ultimately a trial attorney when you, I will say, locked into being an attorney?
Yeah. If I did not go over that in the first or second podcast, the answer is this. And it's ironic. I just presented to the Monmouth County law clerks about this, which is when you enter private practice, if you have the ability, go do everything, right? Because we don't know. Law school does not fairly represent our profession. You know, doctors are in a better position because they have residencies where they do the surgeries and they stitch people up and they diagnose illnesses. Well, for lawyers, we look at books and we take tests, and it's not a fair representation of what we do for a living. So when I became a lawyer, I was very lucky to be able to go into different areas of law. None of them felt really natural except for litigation, except for courtroom experience. So doing bond law, for example, I didn't jump out of bed and be like, man, I can't wait to negotiate this $50 million bridge issue.
Right. And I'm going to interrupt and just say, when people say you didn't learn a specific area in law school, what I think people don't understand is we graduate from law school being general practitioners, meaning,
which nobody does.
Which means we have a little bit, very little bit of knowledge about a lot of different topics, but we are not an expert at any one of those topics.
That's exactly right. So in that mindset, when you go into private practice, you throw yourself into the things you may have interest in or you may be good at. And when you find the ones, then you have to become the expert at it. And that's why I've talked to you about this before. I did years and years and years of public defender work and really cut my teeth on the hardest, most grimy, challenging cases that were out there. And now it is puts me and you in a position where we're just not intimidated because we don't have imposter syndrome because we did those things.
Right. Well, when you're in court and you're getting yelled at by judges and defendants alike,
Yeah.
uh,
I mean,
and you're able to later, be able to have a thick skin and just,
it's exactly right.
you know.
Yeah.
But I will say that, when you say do lots of different areas, which I agree with completely. I would also add, if you know you're in an area that you don't like right away,
Get
get
out.
out of it.
Get out.
And because a lot of attorneys, I will just say the last on this point is, I think I was a rarity that I knew I wanted criminal defense work. I I applied to the Public Defender's Office in Philadelphia. I got the job at the Philadelphia Public Defender's Office. So I had like a very straight line.
Yeah.
But I had a lot of friends who took the job that was offered to them, even
Yeah.
if it wasn't in the area of law, and then those friends sometimes got stuck. And I would say, get the experience and get out and find something new,
If you
right?
can. I mean, that's always the if you can. I literally just talked about this with the law clerks because they were saying, well, what if you get hired by this firm that only does insurance defense and that's what you end up doing? Then that's what you end up doing. But you have to recognize that you're pigeonholing yourself.
Correct. But insurance defense is a great way for a young attorney.
Yeah, no, yeah, absolutely. You could then get your depositions, your trials, and all those things in, and maybe you want to go do private practice on the plaintiff side. You are equipped with skills you wouldn't have had otherwise. But 3 years in becomes 4 years in, becomes 10 years in, and then you are a career position that you may not want to be in, or maybe you do want to be in it. But yeah, it's
Right.
interesting. I think we did talk
Yeah.
about that last time, if I remember, because I remember you saying that
So,
you had always known exactly what you wanted to do.
right. Well, I think the thing about being a litigator is it's very similar in a lot of respects to playing sports and being a
100%.
competitor.
100%. Either you like that or you don't. I have lawyers at my firm who work up a file or do the transactional work or the contract work, and their specific thing is if this goes to court, Rich, you know you're doing it. And I'm aware of that, and I'm okay with that
Yeah.
because they don't want to be the in-court person, but they can read a contract way better than I ever will. And they can
Right.
spot an issue in a merger that or an acquisition that I may never see, but I can present it to a board or go to a courtroom and argue it. So understanding your talent, critical.
So, um, was there a specific moment that you knew in your career, I'm a courtroom attorney versus a bond attorney or a merger and
Oh,
acquisition attorney
yeah,
or a contract attorney?
I never thought I was anything other than a trial lawyer. I think that the design of my firm was try different things. Um, but I was never of the belief that any of them would be my career other than a trial lawyer. And what I mean by that was is as long as I can remember, those were the lawyers that I admired. Those were the lawyers who I wanted to be like Matthew McConaughey in A Time to Kill. I'm like, oh man, it's gonna be me one day. So I was, I knew that that was the style lawyer I wanted to be. But at the same rate, when you enter the private, practice and you're at a firm, and even though it's my firm and my family is involved in the firm, there's still this desire to have you be exposed to different areas with other people who aren't your family members. And that was important. I worked for a guy in the bond law industry who was brilliant, a guy named Jack Kraft, and he wrote the book on bond law. He did huge issues of bonds across New Jersey. He was assistant counsel to the governor back in the day, and he was brilliant. What I learned was his brilliance had nothing to do with the type of brilliance I thought I was capable of, which was courtroom presentation to human beings. He could do things that I never even conceived of in terms of book work. I
Mhm.
still can't think about it. When he was saying arbitrage and things like that, going through these contracts, he was a master at his craft. But I knew sitting in the room, spending hours with him, that it wasn't going to be my craft. And that was
Right,
important.
right.
Yeah.
Yeah. And it's also funny how people can get really excited about
Yes.
areas of law that in for me, it would put me to sleep. I have a friend who
Yes.
works for not just national but international law firm, and she does contracts and mergers, and when we talk to each other, we laugh.
Yeah, she's
It is like
energized.
she's energized, and I'm like, "How are we both lawyers?" Because I have no
So
idea what
different.
you're talking about. And
Right.
then, you know, I think this is, like, already, like, 15 years ago, I said to her one day, "What do you think about human trafficking?" Because the new statute came out of, new definitions of what human trafficking was. This is, like, in 2012.
Mhm.
And she looks at me and she's like, "It's bad?"
Mhm.
And
Yeah, it's
then,
bad.
like,
But zero, it's
right,
not like
and
you're on her wavelength. Yeah,
right, she
and
was like, "I have no idea what you're talking about."
sometimes we assume as trial lawyers that everybody loves what we love. And I had that experience recently. We hired a new associate who is doing commercial transactions and stuff of that nature. I said, hey, if you ever want to sit on a murder intake or a catastrophic death case, a wrongful death and injury case, let me know. And she's like, nope, don't want to. No interest. And I'm like, that's so interesting. You're not interested in those things? Not even a little bit. So I
How
respect
old is
that.
she? How
She's
old is
right
she?
out of her clerkship, so 23.
So I will say, I feel like this younger generation knows what they want
Yeah,
more
she
than
was
we
so
do.
confident. I'm like, you know what? And even I was like, you can still sit in on my intake so you can see my style and see another lawyer do something. But I appreciate that what is interesting to me is not interesting to her. And, good for her for being convicted in what she likes, as opposed to what Richie likes. Don't like it just because I like it.
Right.
Yeah.
So how do you define the difference between a lawyer versus what I would say a litigator trial attorney? And I know that for the trial attorneys, we take a lot of pride in the fact that we're
That's a good
trial
question.
attorneys.
I interviewed F. Lee Bailey before he passed away, and he equated his experience as a fighter pilot in wartime to being a trial lawyer. The same type of rush. And obviously, I can't speak to that. I have no type of comparison to make like that. But he made that comparison, and he is the generational trial lawyer that we know. Probably his book's behind me, F. Lee Bailey for the Defense. If you want to read a really interesting book about a great trial lawyer. But that, I mean, that's like the going overboard version of why we're so proud, is because we think we are the warriors. We think we are the gladiators who are in there, and we to a very large degree we are, because I don't think there's that many people can do it. I think that's maybe why we're so proud of it. And I'm not
Right.
saying,
Well, if you do it well, it
no
is a
question.
rarity
I think
because
there's
if
an
you
elite trial lawyer class, and it's very difficult to stand next to those people. And
right.
I believe I am one. I'm just saying that. I believe I am one, and I believe that you
There's
are.
nothing wrong with that. There's
Yeah, and
nothing wrong with
it's good to
that.
feel that way. It's good to feel that
Yeah.
way. But I do think that, like I said, my associate before, who has no interest in being in a courtroom, they know it too. They would say, yeah, I'm a lawyer, but I am not a litigator. I am not a trial lawyer. And I think
Right.
that the difference is, can you go into a courtroom with 12 or 6 strangers, and can you present to them succinctly and emotionally an energized version of the case that would win? Can you do that?
Yeah.
And if you can't
Right.
do that on your feet, a lot of times spontaneously, because some of my best arguments occur in the moment. If you can't do that, then you're not a trial lawyer, and that's okay.
Right.
Yeah.
So I have like two stories to tell. One is about just recently arguing a motion that went very well initially at the beginning of the motion, which was challenging a warrant. So
Hmm.
a search based on a warrant. And I am challenging the credibility of the warrant, really arguing zealously that it was misleading and it had incorrect information. And the judge had asked me a question, and for whatever reason, the way her question was worded, I could not find the specific response at that moment. And so I
You were
went
at a
from like a
loss of
very
word.
I wasn't at the loss of words. She wanted something specific in the
Yeah.
warrant, and
Yeah.
I couldn't find the answer, and it sort of deflated the argument. And
Yeah.
then there were two
Yeah.
other co-defendants, and they argued, and then the state argued. And I'm looking for the line that I'm looking for, and I'm listening to the arguments, and I'm like making notes. And the attorney next to me is about 15 years younger than me. And he's watching me. He's watching what I'm doing. And the prosecutor stops, her argument finishes, and I stand up and I say, Your Honor, I want to answer your question. And I think the prosecutor actually supports my argument. And I finish the argument with like just a knockdown punch.
Because you didn't get rattled.
And the attorney next to me, who was 15 years younger, when we walked out, said, oh my goodness, how did you listen? How were you listening to what she was arguing while you were reading the other stuff?
That's a talent too.
And then
That's a trial lawyer talent.
And then he said, and then you stood up and you completely hit the argument. You finished so strongly that even though it felt like you were deflated at the end of your argument, you actually finished so strong that I think it was better that you missed it. He was like, it was like amazing. And he said, I don't listen to their arguments. I think I'm always so busy trying to like see that I made everything that I needed to, my points, that I don't even listen to what they're saying.
That's a really good story, and it's critical during trial work because a lot of people in that same concept will ask their questions of witnesses and be ready and looking at their next question instead of listening to the answer, which is gold a lot of times. And if you're not, you have to be able to do both. And I think that that's another trait of a great trial lawyer is, can you multitask? Can you be listening and notes and thinking and digesting all at the same time? Because if you can't, it's going to be a whirlwind.
Right. Because the golden nuggets of trial, really, those best moments are when you're having the conversation with the witness, whether they're direct or on cross, and something is said that is unexpected.
Yeah.
That you either know is a complete lie and you're going to be able to impeach them on it, or is so helpful to your case. And what's so great is the way you respond to it.
Yeah.
That is so interesting.
Right.
And the jury will pick up on it as well. But if you're just going through your questions and I'm looking down pretending I'm reading something, right? If you're just looking at your questions, you're missing those golden moments of trial.
Yes, and it won't land with the jury because they're not engaged with you. If you're in a conversation and you're paying attention, you're engaged. If you're on to your next question not listening, they're not listening either. They're not going to. It has to be a conversation.
So I'm going to ask you this question about trial attorneys, because I think you and I probably were born to be trial attorneys.
Yeah, I think there's a little bit of that too.
But I am going to ask you, do you think trial attorneys can be made? Do you think you can learn to be a trial attorney? And are there skills to be had?
That is such a good question. There's something my dad has always said, which I think if you can have me remember one thing, this is it, which is you have to be comfortable in your own skin. If you're comfortable in your own skin, then when you're a trial lawyer, people will believe you. You'll have credibility. You are who you are. But you can't be somebody who you're not. So there's great trial lawyers who are so different, but they're all great in a respect. Like Jerry Spence is different than F. Lee Bailey, who is different than Clarence Darrow, who is different than the one who did Rob Black. Was that his name? The one who did the cross-examination in the Kennedy rape trial in Florida. He was the type of guy who sat at a cross-examination podium and went line by line meticulously for like an hour, just absolutely obliterating the witness. Well, I'm not that guy. I'm more of an in and out, point, punch, out guy. You know your stuff.
That's how I am.
Yeah, know who you are, know what works. And do I think that there's a little bit of, do you have the gift of gab or not? Yeah, I do. I think that that's a relevant thing. Some people just are not comfortable. And like I said, comfortable in your own skin. If they're not comfortable in the courtroom, don't force it. Don't force yourself to be a trial lawyer. There's great opportunities outside the courtroom.
Right. And I do think that there are skills to be learned, but what I say to young trial attorneys is you have to be authentic to who you are.
Comfortable in your own skin. That's it.
And I have watched other attorneys that have been so much fun to watch, that are a little bit more dynamic and like hands and like funny. And it works for them. It works for them.
If you can wear a cowboy hat and it works, then good for you. I can't. and I know who I am. You know?
Correct. And so I'm always like, I am uh, a teacher by trade. I teach at, I've taught at Rowan. I teach now at Stockton. I taught at Delaware Law School, and I'm, a mom of 4 kids, and I
Right.
always find those teaching moments. And I feel like when I talk to the jury and I'm interacting with people in trial, that I'm still in that teacher mode.
And that's a comfort zone for you. So it
Yes.
works, know who you are.
So, um, so I do think there are skills though, and I think people can become better at their craft,
Absolutely.
especially with cross-examination. I think cross-examination is a skill
Yeah.
which we can talk about. Probably we can spend an hour on it in and of
Absolutely.
itself,
Absolutely. But I
but
think direct and crosses, more than maybe anything else, are things that can be honed and things that can be
yes,
perfected.
yes.
Yeah.
And I always say with cross, know what you want,
Get it and get out.
get it, and get out. Don't try to get, you're not on TV. There's
Right.
no Law and Order here. You get what you want, you get out, you put it together in closing, you
Absolutely.
know, and that's
Absolutely.
it.
Yeah.
So where does trial prep begin? Um, when the case is heading to trial.
So,
So,
yeah. Sorry, go
it's
ahead.
not an hour. It's not an hour. It's never going to be resolved in an hour's worth of time, your trial prep and your trial experience, for those TV watchers out there.
It's never ending, actually. It's never ending until it's over. Until the verdict's read, you are at the kitchen table the night before in the hours that go however long they go before you can possibly stay awake any longer. And you're studying what's going to land the best. Because even when I have it all known and I finish and I believe I have every page turn that I've reviewed, I'm still saying what's going to land best, what's going to feel most authentic to this jury. And it's the same reason that comedians practice their jokes on crowds, what lands and what doesn't. Well, the way that's why we do mock trials in my office. We bring in the
Hmm.
public and we present arguments, and one closing or one case theory or theme may land a lot better with the public than another one. And we as trial lawyers think we know it all. We don't. Many times the theory that I thought was going to land is the one that they're all glazed over saying that's not it. And a different one that it was maybe simpler or a completely different angle on my approach is the one that they picked up on. So an hour is a joke. It is never ending from the second the file opens until I get a verdict. I'm figuring out my trial strategy. And that starts, this, that starts when I get the police report that early.
Right. So, but I would say to you that the way I handle cases, um, there are cases that I have as a criminal defense attorney that I have different goals for.
Sure. Oh, yeah.
And that's
Oh,
based
yeah.
on what my clients are telling me.
No question.
Please keep me out of prison.
Right.
I don't care
Get
about
me to
anything
that
else.
point, which is different than getting me not guilty or whatever.
Right.
Get me to that
Versus
point.
trial. So, not all cases that I get, I don't handle civil cases. So I think civil cases are different because
They are. Yeah.
What?
They are. They're different.
Because I think when you get a civil case and you're representing a plaintiff with injuries, you're looking at it always trial ready, right?
Right, because then you get the best settlement, which is different. Like, there's no way I would take a civil case and say, let me hit for half the policy, right? Let me figure out how I can get half the policy. I always want the full policy. And if it's not worth the full policy, I get there by default by prepping it. But I think for criminal, it's a very different analysis because somebody may be saying, look, I'm looking at 10. My kids are young. If you can get me down to a number where I can get home to see them, then that's the number I want to commit to. And and we wrap this thing up. Well, you're not necessarily focused on litigating the case to the finish line or every issue because you need to get to a place. Maybe that involves going into rehab or getting some type of diversionary program opportunity or, a job or money, restitution. Those are all things that impact a goal.
Right. And it changes where they are. I have a client
Absolutely.
who's out of custody, who's saying they're not guilty and they're out of custody and they're working and they're able to continue with their life. They don't care that the case takes 3 years to get ready to even end up on a trial
That's
list.
a really, really good example. It's a really
Versus
good.
a client who's in custody and says he's not
Just wants to get
guilty,
out.
and then all of a sudden gets an offer for probation to be released.
You have time served. You're 100% innocent. You're in jail. Take a plea and get out right now today, or stay in because there's a backlog that could be 2 more years before we hear your case. What a
Yeah.
different analysis that is.
Yeah.
Wow.
So for me, when I'm starting to get trial ready is when I get to a point with a case that I know that it's not going to be resolved, and then I start going to be filing motions.
So would that be
And
plea cutoff for you? Are you doing that at plea cutoff? Because that's probably when you need to start filing those things, right? Or is it before then?
so it really, if it's a case where I see a motion right away, I always try to go to the prosecutor and say, it's a bad search.
Yeah. Let's do this.
Or
Let's
you
get
have
through it.
problems with your case.
Right.
Let's streamline this. Like, let's get to the end result based on what we know. And if there are sophisticated and knowledgeable prosecutors, they're gonna be able to work with me on it. I had a case recently on a vehicle stop and a search of a vehicle, and there was a significant amount of drugs. And I said to the prosecutor, it's a bad search. It's a bad search. And then she wouldn't give me a reasonable offer. It was a 10-year prison sentence.
Hmm.
And I briefed it, and the court conferenced it with us before the date of the motion, like that day. And he
You want
said,
to think about this a little bit more.
he just said, maybe you should think about resolving it. And I'm going to tell you, it was not directed at me. Not my first rodeo.
Let
And
me
so I
ask you
came
this.
out and
I have a
yes.
question for you, I hate to generalize like this, but it's my experience. My experience is that when I have that good argument and I present it to a newer attorney, they don't want to hear it. My experience is when I have a more seasoned attorney, they're more open to it because they've been through this before and recognize that when there's a problem, we should just address it. Do you have those
But
issues?
I think the real issue is a few reasons. One, a seasoned attorney knows the issues.
Yeah.
Where a younger prosecutor,
Still learning them.
candidly, they're still learning. And so I don't begrudge them that. Like, I really understand
I agree
that
with that.
they don't understand that. And also they believe everything in their file.
Yes, they do.
Like,
Yeah. So
and so
I've had to go, and I hate to do this, but I've had to say, look, I'm gonna have to go over your head because this is just a bad search. It is what it is. If you're not going to pay attention to my brief and my motion, and you're just going to be I'm not listening to it, I have to go over your head.
right. But this was a case where we argued the motion, and the officer tried to add other reasons why he stopped my client. The first was for double parking, then obstruction of traffic.
Oh boy.
He wrote my client traffic tickets, and I said, you wrote him traffic tickets, right? Even though he didn't even have a ticket book for 2 hours. It wasn't until other officers came, and then he was like, do you have a ticket book? He didn't write him a
Covering bases is
ticket.
not good.
He didn't write the ticket for the reasons why he stopped the car. He didn't have it for double parking or obstruction of traffic or anything like that.
Yeah.
And the judge ended up suppressing everything.
Wow.
And
Good
then
work.
after the judge suppressed everything, which meant there's no case, the prosecutor said, well, would he agree to a probationary sentence? And
at that point, no.
isn't that, I said no. I was so dumbfounded, but I think it's a really good example of, you don't know what you don't know. And if you're not asking the right people, I always say to young attorneys when they work at a law firm, a prosecutor's office, or a public defender's office, ask the same questions to lots of different people.
Yeah, I get different answers.
Find out who's the smart ones, and then keep going back to them, right?
Yeah, I 100% agree. See who's giving you the right answers. By the way,
Yeah.
for your example for criminal cases, that's true in civil too, because sometimes I'll get an adjuster or a defense attorney who lowballs me on a case where it's obvious that the case is worth the policy or whatever. And I don't want to be like, look, what are you doing? I have to go over your head on this because you're going to waste everyone's time and money. In that case, in that situation, you have somebody who's hurt, and money now to somebody who's hurt is much more meaningful than money in 2 years. So I'm not going to wait. But I have the same kind of experience in civil as I do in criminal, which is sometimes you just have people who are going to try and either lowball you or not listen to the real good proofs. And it's, you know,
Right.
you have to get
And
past
maybe
that.
they don't
They
maybe
may
they
not
don't
see it.
know, but
Yeah.
if you're able to talk to someone right away and they see the injuries
Yes.
and there's no prior injuries and no prior and you're going to be able to resolve that case
Right.
prior to spending a lot of money, right?
Them too. It
Don't
all makes sense.
don't
And it's how it's supposed to work. So, and I have both experiences. I have great experiences where a seasoned adjuster or attorney says, I get it, Rich, it's a policy case, send me your proofs, let's get it done. Great. What's frustrating is the other end of the spectrum in criminal, in civil, anywhere.
So I think that if it's a case that you know right away, if I get an offer right away, that's a ridiculous, what I consider a ridiculous offer. Then I already know from the moment I have that file that I will be prepping for motions and getting it trial ready.
You know where you
And
live.
then there's certain offenses that based on the nature of the offense, I'm pretty sure we're not going to resolve. So from the beginning of the case, you're getting it trial ready.
Great example. You're 100% right. Like if you have a murder case, you know you're not getting a sweetheart offer. You know it's not happening. You're prepping that for trial. Same thing with civil. If I have a $5 million policy and somebody has a massive injury, I know it's going. Nobody's just going to write the check for $5 million. I got to work it. So
Mhm.
and I think that there's the gravity of the case you're handling. Every case is incredibly important to the person you're representing, from a careless driving ticket to a murder case.
Yeah.
No question. But this system looks at those cases different. And you have to appreciate that, and you have to recognize where you're working in the system, right?
Right. Right. Well, the municipal court clients sometimes are the hardest because
Neighbor disputes, for
they
example.
could,
A neighbor
yeah,
dispute. I may rather have a murder case. I may rather have a murder case.
I know. And I always say when people call me on neighborhood disputes,
I don't really want it.
I say to them, it's going to be dismissed in the end.
Right.
Everything's going to be
Your
dismissed.
children
It's
dismissal.
not the
Stay
right,
away from each other. Don't bother each other.
right. I was like, it's not the right venue. So
Yeah.
municipal court's the hardest because it's the one court that most people in their lifetime will have an experience
Yes.
with.
Yeah.
If they have a traffic ticket, you're in municipal court. If you have a ticket for not trimming your hedges and you violated an ordinance, you're going to be in municipal court. If you have a neighbor dispute and you file harassment charges, it's a neighborhood dispute. And what I would say about municipal court is it's a case of mediation and negotiation. And nobody and nobody, judges or prosecutors, want to try cases.
Right.
They want, because their caseload, and I'm not begrudging anyone of their job. The caseloads are so high, and most cases are resolvable. And so when you have a real case that needs to be tried, people in municipal court don't understand. They don't understand that municipal court prosecutors are part-time, that they're getting the list that morning, that
Right.
they're,
Yeah. The system dictates it. It really does. Yeah.
yeah.
The municipal court, one thing that's great about municipal court, it's a grind. It is a grind, but it is the fastest way to hone your skills because you're not going to be able to get as much exposure in really any other area. Municipal court, you are in there in court, putting pleas through, putting deals through, talking to prosecutors, talking to police, talking to judges. And for a routine civil case, maybe you go to court twice, maybe over 2 years,
Right.
you know.
Also, if you're a prosecutor or public defender in municipal court, or even if you're just handling traffic tickets and going as a defense attorney, um, you are learning to de-escalate people
Oh, it's
who are
so important.
very stressed,
So
you
important.
know.
Yeah. And that helps us with everything we do in life in and out of our profession. I am more appreciative of a de-escalation mentality now at 43 years old than I ever thought I could be in my life. I want everyone to just take a breath.
Right, but at
Myself
27, you
included.
might have been like,
Myself.
"Let's rumble," right? 27, you're like, "Let's
Right. And I
go."
think that the trial lawyer, that is maybe a thing that's inside of us, is that we always want to fight and we always want to be the pit bull, but there's times where that will hurt you and hurt your client. So I've had to learn to
Yeah.
take a deep breath, don't explode, don't tell somebody you know what in court. But you can still get
What
where you
I
need to
say
get to.
to what I say is, um, I'm North Jersey born and bred, and I say I learned to control the North Jersey anger a little.
I think that's a
Um,
very accurate thing to say.
and what I really have a philosophy of handling everything with kindness and hopefully grace to other people, whether it's someone just having a bad day or someone really stressed out about a ticket. And I try to handle things in a very calm demeanor way. And then if it gets nasty or escalates in a way that's not, then I am ready to rumble when I
Right.
need to
And if it
rumble.
goes there,
And so
fine.
yeah,
Yeah.
yeah. So when you have a case that goes to trial, you mentioned it briefly. You have a jury come in and sort of listen to what will land or not. And I'd really like to focus on understanding or you explaining how you develop a theme of a case and the importance of a theme throughout a trial.
Yes. So I am a firm believer that you need to have a theme. You can start at a paragraph and you can reduce it and reduce it. You should really get it down to what is your 1 or 2 line sentence of what your case means. And that's your theme. And your theme should be weaved into your entire case, direct, cross, proofs, closing, opening. So when they leave, they say, if the glove doesn't fit, you must acquit. That's a great example of a theme, right? And if the jury can marry that theme, you're going to win your case most likely. But you have to make sure that the theme is something they're willing to marry, something that makes sense, something that's landing. Because if you are trying a case on a theme that isn't landing, it doesn't work. So I always am
Right.
very, very carefully looking at, is this a great plaintiff? Can the theme of the case be Mary was a Olympic athlete before she was hit by a truck, and now she has no quality of life. That's the whole story. Everything else just supports that story. Well, that only works if Mary was an Olympic person before, and she can't do all the things that she can do now. You can't lie. So on
Right.
some cases, when you have a bad plaintiff, which I have right now, I have a bad plaintiff with a pretty checkered history, but there was a huge injury with a massive surgery. Well, the whole case is going to be about the surgery. I'm not going to even talk really
Right.
much about him. I'm just going to talk about how horrible this surgery was and how intrusive it was. And that'll be my theme. So I'm always trying to
Right.
think and then when I bring a mock trial in, maybe I'll try both. Maybe they do connect to this guy because sometimes they say, man, he had a checkered history, but he was trying to get his shit together and this threw everything off course. So I play
Right.
with different stories. What's your story? That's where I'm
And
going. Yeah. And
what connects?
what story connects? So when I bring a jury in a mock trial, I'm not trying to see if they're going to like the way I cross-examine Mr. Jones. That's something I have to figure out on my own. I want them to understand, is this a theme that will land and win this case and get a good award of money or a not guilty verdict or not? That's what I'm looking at. That's the prep with the group, focus groups. If you want to, you can also bring focus groups in to look at a specific issue, like liability is a good one. So maybe you have a T-bone accident, and I did this regularly where I'll present the case from the other side. I'll try the case from the other
Mhm.
side and let somebody at my office try it from our side. And then I want to see, do I win the case? Because I don't want to win the case
Mhm.
in that situation. So maybe you have an issue, a
Right.
focus group where you can see what do we need to do to win that specific issue. That was a lot of stuff.
Right.
Does that make sense?
Yeah.
Yeah.
No, it does. And just to add with the theme is that you want to be able to say in your closing argument, the first day that we spoke,
This is
first day
what I
that I talked to you in my opening, I said A, B, and C.
right.
And now we're here and you heard the evidence, A, B, and C.
And it's still
So,
see.
and it's still there. And so that's, I think, what you're talking about the theme being interwoven throughout
It's
the whole
exactly what I'm talking about.
case.
Exactly.
And I think the other thing with trial is when you say you need to know what your theme is, if it takes you 10 minutes to explain your
Not your theme.
your theme or
You
what
lose.
you're trying to share with the jury to win a case, you have lost the jury.
You lost.
And I love the idea of making it tighter and tighter and tighter. So in the end, for example, I had prostitutes charged with robbery, and my theme was this was not a robbery. This was a business transaction
I remember you telling me that.
that
That's a
went bad.
great theme. That's a great theme. Right. And if they leave with that, then you won.
Right.
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 That's a great
So,
theme will win your case. You got to support it, but it'll win your case.
yeah. And it's not always so easy because
No, coming
sometimes
up with a theme is hard. It is
some
hard.
yeah. Yeah. And sometimes you really have to get into the case and the nuances of it so long, start work. Sometimes I'm working on my cross-examination of the witnesses, and it's not until I really get to that. So the last thing I really do on a case is work on my opening statement and have an outline of my closing.
That's the same way I operate. Yeah. Because by
You know,
then you've gotten it all.
Right, but I think some people might think to do it in a chronological order where the opening is the first thing you do, and so you would do the opening, but I think having the witness either direct or cross, depending on what who the witnesses are, because if you know exactly what you want and need from each witness,
Mhm.
you will be able to develop a theme.
Absolutely. Yeah.
So, and for every witness, you need to know what you want and don't want. If you don't know why you're questioning them,
Yeah.
there's a problem.
Right. You don't put Officer Smith on the stand just because he was there.
Yeah.
Yeah.
Yeah. There's nothing better sometimes for me when the state puts on a witness
Oh, I love when it's a meaningless witness.
and I stand up and I go, no
Nah,
questions.
no questions. What was the point of that?
And
Yeah.
yeah, and that's my face. My face is like, I don't know what that was about. They just wasted your time and my time.
I'll say it in closing too. Why did they call Smith? That was a waste of everybody's time. I'll say it. I don't care.
Yeah.
Yeah.
So how do you prepare witnesses? Because and I'm not talking about the witnesses you're going to cross-examine. When I cross-examine witnesses, I'm as sweet as can be until they start lying. I say to them,
Well, you have to be
I say to
invited. You have to be invited to be mean. When they invite you to be mean, then you can be mean.
that's such a nice way to say it. Every witness.
Yeah.
Good morning, Mr. Lomurro. My name's Melissa Rosenblum. I'm a criminal defense attorney and I represent. I'm
Yeah.
going to ask you some questions today. If you don't understand the questions, just ask me to rephrase. I will be happy to do that.
Hey, kill them with kindness. And then when they give you the opening, and they will, they'll invite you to be mean. Like the perfect example of that is when you have to cross a rape victim, which I've had to do, and you've probably had to do too. It's absolutely horrific. And you can't call them a liar. You can't do it. But they may give you permission to get to a more direct questioning than at the beginning. You need to be kind.
Correct.
But they may
Correct.
allow you by the way they're being evasive to your questioning, or by the way their tone is, or their responses to you, where they're opening themselves up to say, are they really being truthful? And then you can go in a little bit. But you can never
Right.
go all the way in on some victims. Children, you can never do it. Rape,
You can never do it with kids.
never
On
do it with.
kids, you have to do it in the sense of being more
Are you sure?
the stupid adult.
Right.
You have to act
That's
like
exactly
the
right.
stupid adult.
That's exactly right. Invite them to make a mistake.
Yeah.
Yeah.
But you also can say, wait, I don't understand.
Right.
Wait, you said this,
Right.
but if that happened, when
Right. You don't
have to be this stupid adult.
You don't have to crush them.
Yeah.
There are people to crush.
And
But you don't need to crush people who are coming to the court with vulnerability and perhaps sympathy. You don't
right.
want to be.
And sometimes I say, I handle victims in domestic violence cases and protection order cases, and when I'm prepping them, and I want to know how you prep your clients, but when I'm prepping them and they express a concern to me about being attacked on cross, I do say to them, when the evidence is so clear that they're a victim, I say, if they're going to attack you, it's going to help your case.
Right. Let them attack you.
That's the reality of it. But how do you prep your witnesses?
Okay. So for plaintiffs or a defendant or parties to a case or witnesses that are supporting my case, I'll bring them in and do direct examination. And maybe on day one, we talk about what they had for lunch. Nothing to do with the case, just so that I can get them situated in a witness stand, distancing, pace, casual conversation like we're at the dinner table so we can develop that rapport. Then the next time,
Also that they understand to answer the question that you asked.
yes, and only that question. Don't go. I always say, I say my example is if you were in a car accident, what color was the car that hit you? Well, the car that hit me was blue. It had a smear of red on the back from a prior accident, I assume. There was a crack in the windshield. A bird shit on the roof. No, it was blue. That's it.
This is what I say to
That's it.
them. I say, "Do you know what time it is?
Yes.
Could you tell me what time it is?" But they never do that. You know that. That
Yeah,
I'm
they said,
like,
"Oh, it's 11:30." It's yeah, right.
and
After
I
the
say,
question asked.
I say, "I didn't ask you what time it is.
Right.
I said, do you know the time?"
Those
You
are
know?
great
And
day one preps because you get them to
yeah,
and then go home and have a conversation with someone you love or your spouse or your friends and talk the way we're talking and see if you're feeling the way that I think that we should be feeling in this courtroom. Then the next time you bring them in, then we talk about what happened that day and we start having a conversation about your injuries. And then after they do it that time, which is inevitably horrible, then we do it again the next day. And then we do it again the next day. And by the time I'm going to do my direct or my witness examination in court, I'm their best friend and they're my best friend. And we're having a conversation.
yeah. So I do all of that. I always tell my clients, I'm sure you do, be honest. If you don't know the answer to the question or if it's confusing, say I don't know. It's okay. I also say to them, I'm going to have the conversation of questions right now so you can see the timing and the momentum of how I ask questions.
Right.
And I say, my questions will not be in this order. I might be asking you
Right.
questions that are slightly different. I said, I am not reading you questions because that's not a conversation.
Right. Let's
And
yeah. And it's good that more important than the question being asked perhaps in that prep session is developing a conversation.
yeah.
Yeah. I'm also a huge fan, by the way, of visual aids to help our witnesses talk. So if you have the car, bring the car up on a PowerPoint or show me where was that, and then you have real interaction. I love interaction.
hmm
Yeah.
Yeah. What do you do with a client or witness that you can't control, that you have real concerns about?
Oh, you
You
have.
know they're going to be bad witnesses.
I have had those many times, and what you do is you try to harp on it that credibility will win or lose your case. Even if you think you have the best case in the world, if you are not credible, you will lose. So you have to stop going on and on and on. Answer you try to be brief. You try to be brief. And
Yeah.
we have
And
to,
I,
we have to find the person that if someone is really bad, you find somebody else to tell the story.
yeah. 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 I had a municipal court trial that ended up neighborhood dispute that ended up getting dismissed this week, but it's like a 2 year and a half old
Oh,
case. And my witness, my defendant was a nervous Nelly woman. Like she just was so
so
scared. She was a
so hard to put down.
professional,
Yeah.
no prior record, and I literally needed a third neighbor. So it was two neighbor dispute, and I had a third neighbor that was going to come and tell the story
That's
because
perfect example. She couldn't do it. She was
yeah,
too upset. And you
she
have the
couldn't.
too upset client or the too upset witness, and they're not gonna get what they need to get across. So you did a great job thinking
No.
outside the box there. Who else can
Yeah.
tell the story?
Yes. Okay. So we talked about prepping witnesses, theme of a case. Um, I think the most important part of a trial is actually rules of evidence
Oh, sure.
because I think our job as lawyers, we need to know what we need to get in as evidence and how we need to get it in. And for non lawyers, you might not understand just because you have a picture per se, that picture does not automatically come in.
Right. Got authenticated.
Just because you have a recording,
Yep.
it doesn't mean it automatically comes in. There are rules of evidence,
Yeah.
and I take every piece of evidence that the state or opposing counsel is going to utilize, and I am trying to figure out if there are ways for me to keep that evidence out.
Right. That's
So if I'm
huge.
reading the
Especially in the area of law that you practice, it's the most critical.
Yeah, and
It's the
so
most critical.
sometimes I see reports that have hearsay information in it. So I know there's like not really statements not attributed to anyone,
Right.
so that person can never come in. And I'm prepared for when that officer is going to testify and say, um, "I heard," and I know I'm going to object as soon as
Yeah,
I
your ass is
hear
out of his
that.
seat before he finishes his statement. You need to be ready.
Correct.
Yeah, you need to be ready.
And so I know what I'm trying to keep out, which means I need to know the rule that's going to keep it out. And when I want something in, I need to know the rule to get it in.
Yeah.
And I will tell you, sometimes in restraining order hearings or protection order hearings, which are the rules are a little
They're muddy.
lax.
Yeah, they're muddy.
I had a forfeiture hearing last week, and the prosecutor was showing the witness, um, I think, a written statement to refresh her recollection. And he said,
Start reading
"Well,
it.
didn't you?" And I said, "Objection." And the judge looked at me and I said, "That is not the way we refresh someone's recollection in the
Right.
rules of evidence." And the judge, he just started laughing at
Yeah,
me
they
and he
know.
was like,
Hand
he
it to
said
the
to the
witness.
prosecutor,
Yeah, do it the right
"Can
way.
you do it yes." And so, and you need to know the rules of evidence. I mean, do you agree with that? I mean,
Yeah, I think
what's your
for
thoughts on
my thoughts on the rules of evidence are they are the rule book by which we play the game. So if you don't know the rules to the game, you're going to be penalized. Maybe you still win the game, maybe you lose the game, but you're going to not play your best game unless you know the rules. But just like basketball or, what's offsides? You know offsides or you not know offsides? Well, we're always dancing the line of offsides as lawyers. And
a good
sometimes,
analogy?
I like that one. I just came up with that one right now. But I think to know when you're offsides or when they're offsides is really important. And then for you, and I really do mean this, in criminal, it is so, so important. A lot of times in civil, we agree to a lot of things. We agree that the medical records come in, so that way we don't have to all call doctors to testify about herniated discs. We agree that the x-rays come in. We agree that the films come in. And we argue the case more on who do you think is right versus is this an authentic picture of a murder weapon? It's a substantially different thing. And then you have family court, which is even more so a little bit relaxed on the rules of evidence for different reasons. So it depends what arena you're playing. And you bet your ass you should know what rules are going to be in play. In Chancery, for example, have you met the burden for equitable relief? You ought to know that before you even make the application.
Right.
Yeah.
Right, and I'm gonna say that I've won cases on knowing rules of evidence
Sure.
better than another
Yeah. And
attorney.
nothing wows a courtroom from the judge to the clerk to the jury as someone who knows their stuff. Versus someone who doesn't know their stuff, your pants are pulled down.
Right. Well, I will tell you that, my daughter worked at the courthouse one summer, and she watched a trial, and she couldn't believe what the lawyers didn't know.
Yeah.
She was
That's her.
shocked.
That's a nightmare. That's a nightmare. It's bad for our profession.
She came home and she said, "Mom, the defense attorney's closing was 5 minutes
I don't understand.
on a
I
murder
mean,
trial."
I don't. I think that's malpractice.
Yeah, I said, "Really?" I mean, yes, and
Right.
I think because she sees my work, not that she sees me in court all the time,
Yeah, just the amount of
but she
effort you
just
put in.
was
Yeah.
yeah, just the shock of it. So, when you are in trial, when the trial is starting, tell me your I'm not even gonna say pregame rituals, but
Oh no,
that
I have pregame rituals for sure.
let me hear the pregame rituals then.
I am in my nature a pretty anxious guy, so I'll get up really early and work out, like exhaust myself. So when I get in there, I'm not ready to run through a brick wall. I'm ready to be composed. Right, exactly. So in a way, I need to do that. I understand that that's who I am, and I will try and get those kind of feelings out of me before I go to court so I can be level headed. I like to work out in general. It's part of my day. It's part of my life. But especially when I'm in trial, I'm going to kill myself before I get to court. Second thing, I don't eat lunch because I can't. When you ever eat like a big sub and you're exhausted afterward, I can't allow myself to not be on. So I'll have like maybe a water and an apple or something at lunchtime. By the way, you have to limit how much water you drink during the day. I'm not going to get up and go to the bathroom 10 times during a trial. These are things you don't think of. They're really important.
Right. I will tell you, I have said at like between witnesses, Your Honor, may I approach the bench?
Yeah, I got
And then we go up and I'm like, I need a comfort break.
Yeah. And they 100% respect it. But the jury may be saying, all right, everybody back to the jury's room, 5-minute recess, and they get mad at you. So you don't want to do it a ton of times. I also,
Correct.
I like to review my notes before I go in that morning. So when I go in that morning, so if after I work out, I'm going to give myself enough time to sit down, probably have breakfast in the courthouse, most likely, and review my things before we go in and set up. And I'm an early guy, but I want to be in there and ready to go. I'm never going to be late.
Right.
Yeah.
So what's funny is everyone has their rituals,
Oh,
by the
yeah.
way.
Yeah.
My former partner, who is probably the most anxious person you've ever met, who pretends that he's not an anxious person,
There's a lot of those. Yeah. Might be guilty.
literally had Pepto-Bismol.
Oh, sure.
Like
Yeah, you
the drinking
you
of
better protect
like
all those concerns. Yeah.
sweating,
Yeah, it's
right
I do
there.
think that those things have gotten easier and better now that I'm 43 and I don't feel like imposter syndrome at all, and I feel like I belong where I am. So, and I also, you become a little more comfortable with the realities of life when you're our age anyway. So when you're younger, you may be nervous that maybe your tie is crooked or your pants are untucked. I've ripped my pants in court accidentally. I've been through all that. I don't embarrass easily. So I think
Yeah.
that those nerves have perhaps subsided a bit. I do think that I am pretty strategic about the clothes I wear. I always want to be very presentable and wear a nice tie and wear a nice jacket and the flip side of that is you could have somebody who feels really good wearing Dockers, a sports coat, and like Skechers, and that may play for them. So you have to know
Right.
what plays for you.
Right. Well, I know I talked about an attorney who like purposely male attorney played like the bumbling professor type
Absolutely,
who was,
absolutely.
I am going to tell you, I have my suits, first day suit, second day suit,
Yeah, yeah.
and I used to when I was younger, before I hit the age that I would rather run than wear high heels, but I used to wear high heels. Um, I no longer can anymore.
Shoes are
Um,
important, by the way. Like if your shoes are, and I hated that I learned this. I learned it. Thank goodness I learned it not the hard way. I learned it in I went to get a master's in trial advocacy at Temple University, and we did mock trials there. And one of the mock trials, the jury was criticizing my shoes as opposed to thinking about anything that I had presented during the trial. After they, oh man,
well, it,
that guy's shoes were not polished or something like that. I'm like,
in
it's never
in
happened.
my in one of my first trials in Atlantic County, that was what the jury spoke about were my shoes.
Right?
And so I wear high heels or wore high heels during trial. And I would wear fun shoes at times that were pink or purple or, but I would never wear them the first 2 days of
Right. You
trial.
gotta
I
earn that.
wore,
You gotta earn the ability to do it first.
and then when I wore my first pop of color in the heels, it would be in pants where they're just peekabooing. I mean, like, and you think I'm crazy on this, but women are judged so
I
harshly
100% agree with you. I think it's so
because
terrible, but it's true. I just had this conversation. Do you think that women need to wear those type of shoes anymore? And I hate that maybe they do. I don't know.
yeah, well, I mean, the truth is, I can't. I
Right.
ran a marathon last year and I was in PT for 6 months afterwards. And my physical therapist said to me,
Never again.
I don't think it was the running. I think it was the heels that you had 2 weeks
Wow.
during your training, during a jury trial. And he said, do you want to run or do you want to wear the heels? And I run for my workouts, 3 to 5 times a
Right.
week, not a
3 to
day.
5 times a day would
And
be pretty remarkable.
that would be, and working a full-time job, but it's so important to my mental health and my
Oh, I have
happiness.
to do it. Have to do it.
And And so the shoes that I wear now, they're so funny that, I'm wearing like a nice suit. But those are things back to the courtroom that are really aware that we are sort of um, being judged by a jury
Always.
on lots of different things. And it's not
Always.
just about the case.
Yeah. Yeah, it's sadly that is true because it shouldn't be that way, but it is that way. And we have
Right.
to recognize it and make it part of our routine.
Right.
Yeah.
How do you adapt to unexpected situations in court? Do you feel like you're uh, able to react to it? Do you have a
Yeah.
poker face? Do you
I
thrive off of it, or does it
I think I do enjoy
derail
it.
you?
I think I enjoy curveball because I think I'm good at them. Bring it. I'm a trial lawyer. Bring it.
Yeah.
I'm good on a curveball. I'm good on you trying to catch me. And if you do, then you got me. But I'm not going to shy away from the last thing I'll do is huddle down and say, "Oh shit." It's just not going to happen.
Right. So I always say that before trial begins, it feels like the beginning of a soccer game. I don't know if you played soccer,
I
but
played
the
sports my whole life, so I can relate.
so so the whistle blows and you have this
Rush.
jitteriness,
Rush.
rush,
Never goes away, by the way. Never goes away.
and then within the minute,
Yeah.
30 seconds
You're
to a
flowing.
minute, it all the noise just diminishes and you're in.
I could not agree with you more. I feel comfort when I'm up giving my opening. I'm in there. I'm cruising. But preparation is key for that. If you're not prepared, you don't get over those jitters. If you're
Right.
prepared,
Well, the best,
then you're good.
right. And I'm going to say that I think that what will calm any attorney, whether it's your first trial or not, is being the most prepared in the courtroom.
No question.
I think that you might not be the strongest cross examiner when you start. You might um, still need your notes on direct. Listen, I do my closing and openings. I have it all written out.
Mm-hmm.
I know it well enough that I can look up at times, but I have it
Still there
there.
for your crutch, yeah.
But being prepared, I always feel like when I'm in trial mode that I should know the case and try to know the case better than everyone else in the courtroom.
Yeah, you have to. I couldn't agree with you more. And that goes to anything that you're doing in terms of speaking or presenting. If you're speaking or presenting something, you better be the most knowledgeable and the most prepared person. Otherwise, if somebody knows it better than you do, you haven't done your job.
Right.
Yeah.
Right. So before we wrap up, I just have advice for new trial lawyers, advice for
Get
law
in there.
students.
Get in there. Get in there and give it a try. And if you fall flat, do it again, and then do it again, and then do it again. Nobody stood up and did great the first time. Everybody falls. But don't allow it to discourage you. Don't allow it to keep you out of the game. Shoot another foul shot. Shoot them till you make them.
Yeah. And it is somewhat of a skill. I know that when I started in Philly at the public defender's office, we started at preliminary hearings, which are probable cause hearings. You have 2 minutes to ask maybe 5 questions.
Rapid fire.
And you're not winning a case at a preliminary hearing, but you're learning some basic skills to cross-examine,
And that's
you know?
exactly what I'm saying. I'm not saying you need to go try a murder case, get in there and try a murder case. Get in there and try a motion to dismiss a bad search. Get in there, period. And even if you're going to
Right,
lose it, if it's an argument that's worth being made and you're going to lose, make it.
right. And ironically, the attorneys that don't file these motions and won't take the case to trial, prosecutors know,
Oh, they know.
opposing counsel know, and they're not worried about you because they know you can't try the case.
Let me tell you something. That's also true in civil. I had a discussion with an adjuster the other day, and they told me, and I'm not going to repeat the law firm who they were referring to, but, when we get cases from them, we know that they'll just settle for a small amount of money to get the money and move on. And I'm like, that is outrageous to have that reputation. And that you wonder what's the difference between hiring one lawyer, hiring the other lawyer. That on its face is pretty telling.
Yeah,
Yeah.
I agree.
I
I
also-
agree. I know it's sort of, I think that this is why, as someone who's been practicing almost 30 years, um, that people say, "How do you do what you do?" or "How do you continue doing it?" And I say, I am still shocked.
But that's a
I
good thing.
still
It's good.
can be shocked.
Yeah. That's a fun thing to have great days ahead of you, because some professions, the perfect example is a professional athlete, their best days are behind them probably at 30, 35. And for trial lawyers,
Yeah.
you can have your best days until you can't stand anymore, which is pretty cool.
Right.
It's pretty cool.
Well, I'm running a 5K tomorrow.
Let's
And I
go.
can tell you that my fastest 5K days are behind me.
But you're
I
still
am
running.
now, I'm still like the little engine that could.
Yeah. I have a fun run in the morning with my son at his school, 2nd grade. So there will be no record breaking, but it's going to be super fun. I can't wait.
It would be funny if you
Yeah, if I
it
booked
was
it,
a race.
I was like, yes, see you suckers. Somebody watch Zach, because I'm out of here. Yeah, that would be pretty funny, actually.
Oh, well, thank you so much for coming. I know it's always great talking to
It is.
you.
We have
It's
fun.
Such a nice conversation. If you want to know more about being a trial attorney, I would say call Rich.
Yeah, go
He
ahead.
has lots of advice.
Bring it on.
There you go.
All right, good to
Thanks
see you.
again.
One of the best ways to support Melissa and the Mighty Merp podcast is to go to our YouTube page, find the subscribe button, open the menu, and click the bell icon so you actually get alerts when we post new episodes or shorts. For any questions or interest in podcasting, go to legalpodcasting.com.